Welcome to Prism TV's Rights and Security, a program that discusses national security issues. I'm your host, Yahya Abdul Rahman from Ottawa. On Monday, June the 6th, before a packed courtroom, Ontario Supreme Court Justice Robert Meringer announced his decision to commit Dr. Hassan Diab, a Canadian citizen of Lebanese origin and former Ottawa sociology professor, for extradition to France to face charges of being involved in an attack on a synagogue on October 3rd, 1980, in which 4 people were killed and more than 20 others were wounded. Up until the time of Monday's decision, Diab, who was initially arrested by the RCMP in 2008 in Ottawa, had been living at home with his wife while on strict bail conditions, but was immediately taken into custody after the June 6th ruling. Justice Meringer ordered Hassan's extradition solely on the basis of handwriting evidence that internationally renowned handwriting experts found to be totally flawed, and which the judge himself described as, quote, very confusing with conclusions that are suspect, end of the quote. Justice Meringer further concluded that France presented a weak case and that the, quote, the prospects of conviction in the context of a fair trial seemed unlikely, end of quote. He went on to say that, however, it matters not that I hold this view, and argued that his hands were tied by Canada's treaty with France, even though he also states in the decision that if evidence is not strong enough to proceed to trial, it is not strong enough for extradition. In his written decision, he goes on to describe the evidence provided by France as, quote, replete with seemingly disconnected information, while providing some conventional evidence also contained a great deal of argument, hypothesis, conjecture, and references to information received without describing the source of that information or the circumstances upon which it was received, end of the quote. In his ruling, Justice Meringer also acknowledged that Hassan Diab has a great deal of support. Many of his friends and colleagues from Carleton University and elsewhere have provided unrelenting support. Hassan Diab has consistently proclaimed his innocence and sworn that he is a victim of mistaken identity. Stamps in his passport, his lawyers assert, prove that he was not in France at the time of the attack on the synagogue. France states that Diab's handwriting appears on a hotel registration card, but his defense team have vigorously denied this fact. In a press conference held a few hours after Justin Meringer's decision on June the 6th, Diab had released the following recording, which we will now watch.
This is Hassan Diab. I had nothing to do with what the French authorities alleged against me. I'm not responsible for what they claim. I was not in France on October 3rd, 1980, when the hateful attack against the synagogue in Paris took place. I very strongly condemn that attack. I am against any sort of racially, ethnically, or religiously motivated discrimination and violence. I denounce all such acts. My unwavering moral principle throughout my life has been promoting equality and respect for all. My family, friends, colleagues, and students can easily attest to this. People who have known me for decades and I remain deeply disturbed by the allegations against me. I am innocent, and these allegations are baseless. Over a year before I was charged, a French journalist informed me that I was under investigation for this horrible act. Despite this troubling news, I remained in Ottawa. I did not flee, and I was not afraid to confront all accusations to clear my name. Canada's extradition law gives enormous advantages to foreign countries at the expense of Canadians. According to Dr. Gary Botting, a leading Canadian extradition expert, extradition law is the most unfair process in Canada. The Canadian court presumes France's evidence is reliable, despite its fatal flaws. The key evidence against me, shoddy handwriting analysis, was admitted as evidence. This is despite the powerful testimony of 3 leading handwriting experts who demonstrated that the analysis is totally flawed. Moreover, my palm prints and fingerprints do not match those of the suspect, yet this information was excluded by the court and was not considered. Many ask, why bother to fight extradition? Why not go to France, face trial, and clear my name? Unfortunately, under France's anti-terrorism laws, I will face charges based on secret intelligence that I cannot challenge. Human Rights Watch has documented the use of secret intelligence in terrorism cases in France. Moreover, my ability to challenge the handwriting analysis will be severely restricted. This is confirmed by the French legal experts consulted by my lawyer. I reiterate, I am innocent of the charges against me. I will take every legal opportunity to clear my name, and I look forward to the day in which I can reclaim my life. I intend to continue my fight in the court and look forward to the Canadian court rectifying this injustice. Finally, I'm deeply thankful to my lawyer, Mr. Don Bain. I also thank my family, friends, and supporters who have stood by me during this most difficult time of my life. May justice and truth prevail.
And that was Hassan Diab in a June 6 recorded statement maintaining his innocence. And then on Thursday, June 9th, Diab's appeal lawyer, Marilys Edward, told an Ontario Court of Appeal Justice Eleanor Cronk in Toronto that the case against her client is so shaky it would never even be put before a jury. The following day, on June 10th, Justice Cronk ordered Diab's release. It was not until Monday, June 14th, however, that he was released from the Ottawa Detention Centre. And Hassan is required to have a GPS tracking system reattached to his body at all times, which cost him close to $2,000 per month to maintain. And he will continue to remain under house arrest with strict conditions regarding his movements at all times, along with over a dozen sureties who ensures he will does not attempt to flee. Over 1,000 people have signed the petition, which was submitted to the Ontario Court of Appeal, calling for Dr. Diab's bail to be renewed. The case could ultimately reach the Supreme Court because it has set a number of precedents in its challenges to extradition law. So with us to discuss this case are members of Hassan's support committee, Rania Tfaily, his wife, and Matthew Behrens, a human rights activist. And also joining us from Vancouver is lawyer and author and one of Canada's leading specialists in extradition law, Gary Botting. Thank you everyone for joining us today. And so I want to begin with Rania. Sorry about that. I want to begin with Rania and ask you, Rania, to take us back to the time at the beginning of when this all began and started. What was your initial reaction when Hassan was, your husband Hassan was initially arrested?
I would like to start before Hassan's arrest. There was a leak to the media in October 2007 in which the French investigation was leaked to a French journalist in Le Figaro, who came to Ottawa to interview Hassan and to inform him that he's under investigation and that France is going to request his extradition. Hassan denied any involvement, and he clearly stated that he's willing to cooperate with the investigation to clear his name. However, shortly after that, we started noticing that the RCMP, whom at that time we didn't know they were the RCMP, they were following us, intimidating us. We were put under strict surveillance. Cars were following us in an intimidating manner. There was an attempt to break into our home. We tried calling the Ottawa police many times to report these incidents, but nothing happened or came out of it. On November 13, 2008, Hassan was arrested, and our homes and cars and workplaces were searched by the RCMP. Of course, it was very shocking, and I'm still in disbelief that this is happening. And we have been going through the legal process in which we started to discover more about how unfair Canada's extradition law is.
So I know that you and Hassan are both very educated people. You both have PhDs. You're a tenured professor at the University, Carleton, and Hassan was also teaching there and at the University of Ottawa. And so what has been the personal, like the personal impact on your personal lives and on your careers, and especially the very rigid bail condition? Maybe you could discuss that a little bit. The bail condition, like I mentioned it in the opening, but the bail conditions that Hassan is under, and how does that impact you in your daily, trying to go about your daily lives?
There is like personal and as well as financial impact. Regarding the personal, whenever you get involved with the court, Crown prosecutors often try to tarnish your reputation, whether for Hassan or even for me. So this would have negative effect because you would have all of these articles written about you in the newspapers for everyone to see. You also have to go through the bail process, in which Hassan was subjected to very strict conditions. So he can't leave Ottawa and Gatineau. He can't leave the house unless he's with one of his sureties. He has curfew from 9 p.m. till 7 a.m. He can't even own a cell phone. And above all, he has to pay for his liberty. So every month we have to pay $2,000 for the GPS, which the RCMP and the government have refused to pay for. Otherwise, Hassan would risk going back to the detention center. So in terms of the personal impact, you live with these bail conditions on a second-by-second basis. You are always aware that you are under surveillance. Any alleged breach could mean that you are going to lose substantial amounts of money. Hassan would go back to the detention center. So all of the time, you are always afraid, you are always conscious. So if we were in public and Hassan wants to go to the washroom, I have to stand outside. And the same happens if I want to go to the washroom. And we had to get clearance from the judge to be able to do that. If we are in the supermarket and we forgot an item, both of us has to go together and then come again. So we have to be attached all the time. So there is this personal cost as well as the financial. I'm the only person who's working because Hassan has lost his job. He was fired from Carleton University. So there is one income, which is not really high. So having to pay for the GPS as well as for the legal fees, it has been extremely exhausting.
I mean, I know that you mentioned just as we were preparing for the show that Hassan was not even able to come to the studio today because it's just a little bit outside of Ottawa, and it's only like a half an hour drive outside of Ottawa. So his movements are very, and I guess the things that we take, the movements we take for granted, is you have to be constantly all the time watching every move that you make. I want to. There's a question, of course, that keeps coming up for some people, and the answer to this question will come up again and again in the course of this interview. And what people may, many of the viewers that are not familiar with the case may ask is that, as Hassan said, why doesn't he go back to France to face his accusers? And I quote Hassan in his statement. He says, "Many ask, why bother to fight extradition? Why not go to France, face my trial, and clear my name? Unfortunately, under France's terrorism laws, I face charges based on secret intelligence that I cannot challenge." Would you elaborate a little bit on that?
I mean, many people, they ask, why keep fighting this unfair law? If Hassan were to go to France, first of all, he's going to be deprived from his family and friends. He's going to go to a place where he doesn't know. He will be put in pre-trial detention, which could be lengthy. He's going to face judicial system that he's not familiar with. And the process is not fair. And this is not me saying this. Human Rights Watch have been reporting this, as well as many organizations. Because under France's anti-terrorism laws, secret, unsourced intelligence that you can never tell where it came from, who said so, and under what circumstances, it will be accepted as truth. Moreover, the handwriting, he will not be allowed to challenge it because it is produced by the examining magistrate, even though we had 3 leading experts attack this handwriting report, and the judge basically agreeing that, you know, it is a worthless evidence. Hassan will not be able to challenge it in France. So because of all of these reasons.
And this question is going to come up again and again in the course of this hour. I mean, the issues that you brought up, and we will flesh them out even more. I'm going to now turn my questions to Matthew. And Hassan's extradition hinges on the evidence from a French handwriting analyst, this Ms. Anne Bissotti, who found similarities between 5 words written on a Paris hotel registration card in 1980 with samples of Hassan's handwriting. What is the specific evidence being used against Hassan, and the sources of that evidence, and what is the strength of that evidence?
Well, I think as even Judge Maranger actually concluded, it's a very weak report. It is illogical in some of the methodology that has been used. And to call Ms. Bissotti an expert, and she only had 21 hours of training in handwriting expert analysis. She has a degree in biology and forensics. And as Rania pointed out, the 3 leading internationally renowned experts have basically ripped this report to shreds. They're saying there's absolutely no way that you can draw the conclusion that this is Hassan's handwriting. And this is the French's 3rd attempt. They introduced 2 prior attempts to try and make the handwriting link. Those were shown to be failures. So this is the 3rd try. So this is part of the problem that Dr. Diab faces. You know, the French keep being given these opportunities to put forward new reports, and each time they're torn apart. And as we saw in the decision on June the 6th, the judge clearly found that there were major problems with it. The French and the Department of Justice here in Canada have said the whole case hinges on this handwriting evidence. Everything else, you know, you can just set that aside. This is the so-called smoking gun. And when the Canadian judge is saying, well, it's not much of a smoking gun, the question is, why is it that he nonetheless committed Hassan to extradition?
Well, that was going to be my follow-up question: is what were the reasons, like in the justice's ruling on the June 6th ruling, for his decision to commit Hassan to? I know it's a 79-page ruling, and there's a lot of stuff in there. But what was the central reasoning behind why he said, well, I'm despite my concerns with the handwriting analysis and the conclusions of these French experts, so-called, he still is going to commit, Hassan to extradition to France.
Well, I think part of the problem is the judge himself feels bound by the limits of the Extradition Act, and he doesn't realize that he actually does have some discretion. And as I think we'll talk about later, there are differences in the way in which the Extradition Act has been perceived by the Ontario courts and the British Columbia courts. One of the things that Mr. Maranger said was that not only is it a weak case, but the prospects of conviction, even in the context of a fair trial, and as we pointed out, there is no context of a fair trial in France, is unlikely. And yet, earlier in the decision, he quotes the Supreme Court of Canada in the leading extradition case, which is Ferris, and Chief Justice McLaughlin in that case says that a person cannot be committed for trial if the evidence is so manifestly unreliable that you could not rest a verdict on it. Well, Justice Maranger in the Diab cases essentially said you cannot rest a verdict on it, and yet he doesn't kind of logically follow that through to say, well, if you cannot rest a verdict on it, therefore it must be manifestly unreliable. So it's very unfortunate that he has kind of, I think he's gotten quite confused, to give him the benefit of the doubt. I know it's a very murky area, but nonetheless, when the rest of the case is so weak, it is so circumstantial, and also the judge accepts the fact that the government of France is under no obligation to present the full case against Hassan and is under no obligation to present any exonerating evidence. So you've got this little handwriting report which he himself says is weak, illogical, confusing, and with suspect conclusions. You can have 50 witnesses in France say he's not the guy, but France is under no obligation whatsoever, and neither is the Canadian government to present that.
Yes, and again, all these questions are going to come up again in this hour, and these are very important points when we're dealing with this case. In a May 26th ruling, the Justice Marangé said that any assessment of how French courts handle evidence must be done by Canada's Justice Minister during a late phase of the extradition process. What is your response to that?
Well, again, this is a problem with the interpretation of the Extradition Act, in which judges are essentially saying what the French give to you, or any other government gives to you, should be presumed to be reliable. And with all of these problems, I mean, he goes through problem after problem and says, well, this is a blatant error, but we'll forgive them. This seems to be an inadvertent error, but we'll forgive them. And there's 9 different occasions, at least, in which Dr. Diab's lawyers have pointed out major omissions, inconsistencies, inaccuracies, and the judge in this decision actually admits that that is the case. So if you're presuming a case is reliable, and yet, you know, instance after instance is showing that in fact it's not reliable, how can you proceed? Well, you can proceed because you very narrowly interpret the Act to say that something is presumptively reliable, and that you are not going to use Canadian standards of admissibility. And that's a serious problem with extradition law. The other problem is that by putting it over to the Justice Minister, well, the Justice Minister is in a bit of a conflict of interest because the Justice Minister started this process. So why would the Justice Minister suddenly turn around after a judge has committed Dr. Diab to extradition and go, you know what, I was wrong. I'm going to actually apply the standard that should have been applied in the first place and not actually allow this to go forward. Ultimately, it's not really a legal decision, it's a political decision. The Supreme Court of Canada has said, ultimately, this comes down to, do we want to upset Canada's international relations with the French or any other extradition partner? That's what the the Justice Minister has to decide.
Okay, Ronnie, I want to go back to you again. I'm going to bring Gary Blockley in here in a minute. So, the case against Hassan, her husband, it does, of course, rely mostly on the French handwriting analysis, and that the report that the French had gave said that there's a resemblance between Hassan's handwriting and 5 words printed in a simplistic block letters on a hotel registration card in 1980, and then the internationally renowned handwriting experts are highly critical of the methodology and conclusions of this report. Discuss that a little bit, because it seems I would have liked to have the handwriting expert here we was going to have, but I mean, it seems, how could anybody make a determination based upon, like you say, the person has 21 hours of training, and it's 5 words in block letters, how they can determine that is Hassan's handwriting, and base their whole case on that.
I would like to repeat what Matthew have said, that this is not the first handwriting report that has been submitted in this case. France has submitted 2 previous handwriting reports. We tried to challenge them, and we presented evidence from 4 leading experts that show that these 2 French experts were relying on handwriting that was not even written by Hassan. So what the French expert thought to be Hassan's handwriting samples were actually written by someone else. When we tried to present this in court, the Crown prosecutors and the Department of Justice vigorously opposed our submissions. Finally, the judge allowed us to present this evidence. Once the judge read his decision, the Crown prosecutors announced that they plan to ask for adjournment, which they did. So the case was adjourned for several months, during which we continued to have to pay for the GPS, $2,000 per month, even though it is the Department of Justice that was responsible for this adjournment. In May of 2010, Crown prosecutors, they announced that they are withdrawing these 2 handwriting reports and they are filing a new handwriting report, the one by Bizotti. So again, we asked the 3 handwriting experts to have a look at this handwriting report, and they all said that her methodology is completely flawed because all what she was looking at is the similarities and she was ignoring the differences. So I could have written that hotel registration card and any one of us could have written it because all of us have to write the same A or the same B. So we all have similarities with the hotel card in question. So the main problem was the methodology that she uses. In addition, her instruction was basically to find that Hassan has written the 5 words on the hotel registration card. Even Judge Morangi, in his decision, he points out that the experts interpreted her mandate as saying that she has to demonstrate that Hassan wrote all or part of the handwriting analysis. And even this happened, Judge Morangi said that he cannot infer that she's biased because there is the Crown argument on the other hand. So there have been many problems, and during the court, the 3 leading experts, they demonstrated how Hassan's handwriting differs from that of the hotel registration card, and there is no way you could positively associate him with this writing.
Okay.
I also would like to add that the description of the person who wrote the hotel registration card does not in any way match Hassan. That person in 1980 was described as a man aged 40 to 45 who was European and who spoke French with no accent. Hassan was only 26. He was not European. He's not European. And he certainly does not speak French well.
Okay. Yeah, I was going to mention that the French are introducing some other evidence, like an eyewitness, and alleging that he was there even at the time of the incident, even though his passport indicates that he was indeed not in France, he was elsewhere. And Matthew, I want to go back to you again. And one of the key areas of concern in this case is France's use of on-sourced evidence. And why is it that on-sourced evidence is a concern? What is the major concern with regards to for the sake of the viewers?
Right. Well, part of one of the bedrocks of a fair trial, it would seem to me, is that you get to face your accuser. You get to know where that information is coming from. Because if it's unsourced, how do you confirm its validity? How do you confirm its accuracy? How do you confirm its truthfulness? And how do you cross-examine that? And so just as we in Canada have security certificates where individuals are facing secret allegations behind closed doors that they cannot access, the Supreme Court of Canada said that's not fair. France is currently before the European Court of Human Rights for the same reason, because people are saying you cannot conduct these so-called anti-terrorism trials in a context in which individuals are unable to face their accusers or to know where that information comes from, because anybody can make it up, anybody can introduce hearsay, gossip. We know that in this case, they're using newspaper articles as part of the basis for the case against Hassan as well. Well, you don't normally use newspaper articles in a criminal trial. You only use them in trials in which you do not have the full rights of citizenship, such as in security certificates. That doesn't make it right, but I'm just saying that's an example of how once the extradition process kicks in, you basically become a second-class citizen in this country.
I know that, like this morning, I was discussing this point with somebody else, and I was, just in the course of the discussion, I was thinking, if you were to grab anybody off the street and say to them, the government has an accusation against you, but they're not going to tell you what the source of the accusation is, nor are they going to give you the details, and you're not going to be allowed to defend yourself. Would you accept that? And of course, the answer came back that I think the average Canadian, I think that every Canadian or any person would not accept such a scenario. And yet this seems to be exactly what Hassan would face if he is returned to France.
And it's not just Hassan. There are others who face the process. For example, and this is the real danger of extradition, it's kind of like drones, which violate international law. This is a way by which a government if they can't get you through the front door, they come in through the back door using the extradition process. We've had cases, for example, of Roma refugees who have fled persecution, come to Canada, been found to be persons in need of protection. They are refugees. They have been, you know, accepted here in Canada, and yet the extradition process can interrupt a refugee claim, or it can cancel out a refugee claim. And we've seen that in a number of cases in which an individual has gone to the Justice Minister and said, I'm a person in need of protection. This cannot go forward because I'll face the persecution back home that I fled originally. And what the Justice Minister has done is simply gone to the Immigration Minister and gotten a new opinion. So that's the way in which things which you think are solid bedrocks of Canadian law are being disrupted and interrupted by the extradition process.
Okay, so you are listening to Prism TV's Rights and Security, a program that discusses national security issues. And with us in our studio is Rania, Hassan Diab's wife, and Matthew Behrens, and also one of Canada's leading extradition experts, Gary Botting, whom we're going to turn to now. And Gary, thank you for being with us from Vancouver. I want to begin, and I know that many of these, your response to this question has been addressed in different ways, but I want to get it from you as an expert, that why should Canadians be concerned about this particular case? And on the surface of it, it appears to be a clear-cut case of extradition request from France, and so that they can try and accuse person, based upon the evidence that's before them. I mean, I think the average person on the street would just say, well, France is a democratic country. It's a European country. They have a fair legal system. What is Hassan afraid of? He can go there and face his accusers, and he shouldn't have to worry about it. Why should we concern ourselves with this as regular Canadians?
We have a completely different system, of course, from France. This is based on common law, and that includes English law, most American law, and Canadian law, the good examples of the common law system. France has a system of civil law that's based on Napoleonic law, going back a couple of centuries. They both evolved, if you like, in parallel paths. And the basic premise of extradition is different for the Commonwealth, from the common law countries to the civil law countries. France and Germany, for example, that are based on Napoleonic law, they will not extradite their own citizens. And I think this is an important distinction here. France, if it were in the same situation as Canada is right now, and Canada had made the request, would not send its citizens back to Canada. It would not return the person to the country that is seeking the extradition. Now, in this particular case, there is very, very little, actually no evidence that Hassan Diab was ever in France, and especially on the timing in question. The French, nonetheless, want to extradite him back for trial, and basically to face a Napoleonic trial, which is an inquisitorial system. And the inquisitorial system resembles, in some ways, its namesake, the Spanish Inquisition. We have an inquisitorial system where judges have already largely, I suspect, made up their minds. They have their own coterie of witnesses, including the handwriting witness, the handwriting analyst in this particular case. She is an employee of the court, and the court will take her word very, very seriously. Any witness that the defense brings up in a French court is considered already to be biased. We might consider Crown witnesses to be biased. Well, in France, it's exactly the other way around. The French courts always consider the defense witness to be biased. So what kind of a trial is Hassan Diab going to get if he's returned to France by this double standard system that we have right now, where Canada sends people back, whereas the reciprocating country does not really reciprocate at all? Well, he's not going to get a fair trial there, especially on the basis of intelligence that he can't challenge. He has no idea what the intelligence is or where it's from, what its source is. So it's an uneven playing field. It's just completely unfair. Now, I think Mr. Justice Marangé tried to apply the law as it has evolved in Ontario, and it evolves very fast. Fairness is still the standard, and Mr. Justice Marangé pointed this out. He quoted to and alluded to the Ferris case at the beginning of his judgment to make sure that everybody knew that that was the standard that he was trying to apply. But unfortunately, the Court of Appeal in Ontario has already scrambled, if you like, to reduce the impact of Ferris. And that's the big problem. Marangé feels that he must follow the judgments in the Court of Appeal in Ontario. The Court of Appeal in British Columbia has gone a somewhat different way. And we have voices from courts of appeal, judges who have been a voice of reason and have tried to apply the principles of Ferris, but these are no longer heard.
I wanted to quote Ferris because this is, I think, a very important ruling. It's the Ferris case. The Chief Justice Beverly McLaughlin's judgment in the leading 2006 Supreme Court of Canada case, USA versus Ferris, she wrote, and I quote, "If the evidence is so manifestly unreliable that it would be unsafe to rest a verdict on it, then the person should not face extradition." Isn't this this
right.
Is this not this is the issue with regards to the Hassan's case? Am I correct?
Yeah, well, that's the threshold, and
yeah.
But you have to apply that in a way that is in context.
Okay.
And the courts haven't done so, unfortunately. The manifest unreliability is a no-brainer. Obviously, the court is saying if it's manifestly unreliable, it can't be used. That's the bottom line. But what about things that aren't quite so manifestly unreliable? This is the situation that Marangé looked at. But unfortunately, the Ontario cases have thrown everything out. They've used that threshold value as being the entire value. And so manifest unreliability has to be the standard that the defense has to raise in order to kick out the evidence that is suspect. And that's wrong. It's simply a mistake of what Madam Justice McLaughlin said in Ferris. She's saying, well, if it's manifestly unreliable, it's manifestly unreliable. It's almost a tautology. There are all kinds of unreliability beyond manifest unreliability that equally should be suspect and which should lead to the individual being discharged rather than committed for surrender or extradition.
You mentioned it, you touched on it lightly, but I just want to kind of re-ask the question only for the sake of the viewers, because Hassan's lawyer, Donald Bain, contends that if Hassan were living in Vancouver, where you're at right now, that he would have no chance of extradition to France. Why is this so, and why should this be a concern? And is there a difference between Ontario Court of Appeal's interpretation of Canadian extradition treaty law and the way that the British Columbia Court of Appeal has interpreted the law?
Yes. Basically, after Ferris, there were a couple of cases in Ontario. Anderson is one, Thomason is another, Mock. All of these cases more or less scrambled to tighten up Ferris right away. In British Columbia, they took a more reasoned view, especially Mr. Justice Donald, who is a voice of reason in this matter, in extradition matters here in BC. He took a more measured view and said, look, we have to obey the principles that the Chief Justice has set down. And the court, it's not just the Chief Justice, she's the person who wrote the judgment, which is a very sound judgment in my view. And the Supreme Court of Canada was unanimous in backing her decision. and her judgment. So that's where we're coming from. Some judges, like in the Graham case, which is a case coming out of the Yukon, is connected with the Peltier case indirectly, which is a long-standing case that has been very, very controversial over the years, ever since the 1970s. But anyway, basically, in the Graham case, Mr. Justice Donald tried to reaffirm the principles of fairness unambiguously. You have other judges in other jurisdictions, like Alberta, for example, Mr. Justice Berger. He basically has also tried to be the voice of reason when it comes to interpreting what the role of the judges is. And unfortunately, Ontario is going a different route. And therefore, I think that the Supreme Court of Canada is eventually going to have to revisit this whole issue.
Okay.
And they're going to have to clarify what they meant by this manifest unreliability, as opposed to the converse of that, which is that the record of the case, that is to say, the allegations against the individual, are presumptively reliable, almost the opposite side of the coin.
Isn't it a reasonable? I'm sorry, but isn't it a reasonable request to
kicked around in courts of appeal, and not to the advantage of the individual who's being sent overseas?
I want to back up a little bit, because I know that extradition law is not something that most of us think about on a daily basis. I know that you've been studying it deeply for 20 years, but I have read about, there are about 100 extradition hearings per year in Canada, and mostly involving between Canada and the United States, and that Canadian judges have only denied about half of those extradition requests. How does extradition law work in Canada, and why do critics of the extradition law say about this process, especially in light of the 1999 revamped extradition law passed in Parliament with almost zero debate? And Canada's extradition law before 1999 was drafted at the time of Sir John A. Macdonald. Am I not correct?
Yeah, well, yes, that is correct. And John A. Macdonald, in fact, before he was ever Prime Minister of Canada, before Canada ever existed in its present form, when it was still Canada East and Canada West, Sir John A. Macdonald was the Attorney General, and he was the one that basically set down some of the principles that we're dealing with today. And as the Attorney General, dealing with a murder case, it was also called Anderson, ironically, in Ontario, basically said, you know, if you want my opinion, this guy should be sent back for murder. It's about a black slave who tried to escape from slavery, and in the process was being hunted down, and came across a planter who tried to arrest him, and John Anderson stabbed him, and he later on died. Well, basically, John A. Macdonald was saying that he should send him back, whereas the court, after very much deliberation, had a different opinion. Now, the Court of Queen's Bench at that time, in what is now Ontario, were of the opinion that the Attorney General was correct, that he should be sent back to face what would amount to being a lynch mob. And it was a 2-to-1 decision, and it had to go to a lower court, or a different court anyway, from the Court of Queen's Bench, where it was resolved after a great deal of acrimony on both sides of the Atlantic. They extended into 3 continents by the time the debate was over. So there's some parallels. But basically, the court did decide that on a technicality, John Anderson should not be sent back after it was revisited, and after a great deal of political outcry in England and in Canada. So that's the background of extradition that we're coming from, and it seems that we've come full circle. We're back to the same kinds of issues even now. And ultimately, it's for the Supreme Court of Canada to rescue this situation, because I don't think the Court of Appeal in Ontario has the fortitude to go against its own judgments.
Okay.
In fact, it can't, because that's the precedent that has been set. And this is
I
a
wanted
full
to.
panel.
Yes, I wanted to quote in his June 6th ruling, and I know you've touched upon this, but in his June 6th ruling, Justice Marangé stated that, and I quote, "There is no power to deny extradition in cases that appear to the extradition judge to be weak or unlikely to succeed at trial," end of the quote. Is this true, that he does not have any power whatsoever? Or does he have some latitude? It appears that in other cases, the judge does have latitude.
This gives him all the latitude he needs. Well, let's look at the converse. If that isn't the case, then why are we having these hearings at all? As Anne Warner mentions in one of the articles that came out shortly after the Extradition Act came out, why have judges at all? If we give them so little power, they have so little to do. You know, a judge goes through 10 years of training and education, 10 years at least of practicing law, possibly 10 years more as a judge, sitting on the bench before he refines, before he becomes a superior court judge. And now he's not allowed to make any decisions. What kind of a foolish system is that? We need, red judges constantly make decisions that are of high import in civil cases and in criminal cases. They often sentence people to years and years and years, sometimes life sentences in prison. And these are discretionary decisions that judges are given. So they have the discretion at that level. But when it comes to extradition, they crawl under a rock. They don't want to be, they don't want their opinions to be broadcast, particularly. They want to toe the line, they want to follow precedent, and they scramble. And the rock, symbolic rock, if you like, is the precedent that they can hide under. It's quite discouraging because judges are smart people, and we're marginalizing them. This whole system marginalizes them. John A. Macdonald said that the court ultimately is the arbiter of these kinds of issues. And that's the way it should be and the way it was for many, many years. Now, it didn't result in a lot of extraditions initially. And after the Second World War, almost no extraditions. But now we have a new system in place which takes all power away from a judge. And as long as we have courts of appeal that are going to whittle away any positive judgment that we get from the Supreme Court of Canada and make that court powerless and make the Act powerless and make themselves powerless, then we're on a slippery slope. And I think we're way down the slope already, but it's possible to climb back up. What we need is people, judges like Berger and Donald and other judges that have spoken out against the extradition process. We need more judges like that, and judges that are able to scratch their heads and say, for goodness sakes, this is a ridiculous system. I'm not going to play the game the way other judges have played it. I'm going to follow the directive of Ferris. I'm going to follow the directive of the Supreme Court of Canada and its Chief Justice.
I wanted to, after Justice Marangé's June 6th ruling, Hassan's lawyer, Donald Bain, stated the following. He said, "A Canadian is being shipped to France, and the cruel irony is he will not have his evidence judged by the same standards in France because the French in their system do not regard defense evidence reliable." What does Bain mean when he says the French in their system do not regard defense evidence reliable? What does that term mean?
Well, it comes back to basically the inquisitorial system as opposed to the adversarial system that we have in Canada. An inquisitorial system, the judges do ask the questions basically, and their witnesses are called. The defense is obviously bringing in evidence that it is, in the opinion of the judges, biased. It's already twisted towards the defense. So, yeah, it's going to be marginalized by the judges, and that's why Mr. Diab cannot get a fair trial in France, in my opinion. Okay. Especially with all the intelligence evidence that is unchallengeable in any case, because he hasn't been able to see his accusers.
Okay. Thank you. I'm going to go back to Matthew now and ask you, Matthew, that according to a July 2008 84-page report from Human Rights Watch, France's willingness to use information from derives from torture and to prosecute terrorism-related cases is well documented. Why is this a concern in the case, in Hassan's case?
Well, again, because there is the possibility in this secret, unsourced intelligence that some of that may have come from torture. In and of itself, that's morally wrong. It's also illegal under the Convention Against Torture. You can never use that kind of information, and certainly in a Canadian court, that kind of evidence should not be admitted.
Okay. And Gary, how do you think that the Ontario Court of Appeal will rule in this case? And if the case reaches the Supreme Court, which seems likely, what is the likelihood that Canada's top court would rule in Hassan's favor? I know it's a kind of a crystal ball kind of question, but...
Well, you have to get there first, and of course, the Court of Appeal may surprise us all. If they have a 5-judge panel, for example, they could overrule Thomason and Anderson and get back on track and not be quite so embarrassing to the rest of Canadians. Ultimately, that's the decision here in extradition matters. The question becomes, does this affect the conscience of Canadians? Does this impact on the conscience of Canadians that we're sending somebody back to France? And hopefully the courts, or the Court of Appeal in Ontario, the 5-judge panel, will be able to say, yeah, this is against the conscience of Canadians. If that judge, or sorry, if that court doesn't act in that way, well, then it will go on to the Supreme Court of Canada. If a regular panel deals with it in Ontario, a 3-person, 3-judge panel, then it's just going to follow Thomason and Anderson, because the system dictates that we do that. Unless, of course, they can distinguish this case from those cases on the basis of the facts, which is something that has not been done so far with any great success. Okay. I think that's probably the first approach that would be taken. And ultimately, though, we'd end up in the Supreme Court of Canada, because anywhere you go, the Minister of Justice is probably going to appeal. And even if Hassan wins the appeal by going, in the Ontario Court of Appeal, undoubtedly it's going to go on to the Supreme Court of Canada.
Okay, thank you. I just want to remind our listeners and viewers that you can submit questions online. If you look at your screen, there is a chat box there where you can submit questions, and we're going to be taking them, and we'll read them online. You don't have to reveal your name if you don't want to. We'll read them online and submit the questions to one of our panelists here. So feel free to submit any questions to any 3 of our guests here online. Matthew, how do you respond to the federal Crown Attorney Richard Kramer, who told the appeal court that arguments about the reliability of the French government's handwriting analysis are a matter for trial, not an extradition hearing, and that it's not up to Canada to dictate to another country how to use secret information in legal proceedings?
Well, again, I think this comes back to, why should someone's life be completely uprooted and destroyed when you know that the case is not very strong to begin with, and it's not going to be a fair trial on the other end of the extradition process. This is this kind of approach that the Canadian government often, that in the cases that I'm familiar with, has been taking, which is basically, don't worry about it, you can clean up the mess when you get there. But as we've seen in numerous cases of people who have been extradited, well, they go and try and clean up the mess, then it becomes difficult, for example, to get back to Canada. We've seen that in the case of Gary Freeman, for example, who was extradited on a very weak case to the United States in Chicago. He did his time, 30 days in a Chicago jail, and now he can't get back into Canada because they're saying because of the conviction in that case, he pleaded guilty to one of the charges. Now he's inadmissible to Canada under the Immigration Act. So yeah, he did go and sort out the so-called mess and did 30 days. That shows how weak the case was against him. Why should someone have to do that? Why can they not have a fair process here in Canada? Because otherwise you lose your presumption of innocence. What happens to those rights when you are accused of doing something that you lose all rights to defend yourself here in Canada?
It seems to be, like on the surface of it, it seems to me rather a harsh statement to say that Canada does not have the right to dictate to another country how one of its citizens are going to be treated in their courts there. I think that if it seems reasonable to me that Canadian citizens should be subjected to the same level of justice standards as anybody, even in France, right? I think that France, if there was the opposite, that would also probably be the case. They would expect, in this case, as Gary mentioned, we're not allowed to, extradite people back to. French citizens will not have their citizens extradited because of their legal system. It's against their constitution.
And what happens in the event that we have an agreement with a government? Let's say we have an agreement with Colombia, and we have a free trade agreement with Colombia, and there are trade unionists in Canada who send aid to trade unionists in Colombia. Well, we know that the Colombian regime treats anyone who speaks up for their rights as a terrorist. So what happens if in Colombia, a Canadian is charged with aiding and abetting terrorism because they support trade union groups, and then they're sought here in Canada? So we just throw out your right to challenge what is a fundamentally flawed and unfair process in Colombia? This is, I think, the real danger of extradition, is it becomes a form of persecution by proxy. And lots of people in this country could face that kind of persecution, especially if they're involved in overseas solidarity efforts or in partnerships with individuals in other countries.
Okay, so we have a question from one of our viewers, and we'll want to read it here. It says, why is Mr. Diab's case one of the first extradition cases that has received this level of public attention in Canada? So I guess I'll ask this to Rania. Why has this case been one of the first extradition cases that has received such a high level of public attention?
I believe because, as Gary mentioned in some of the interviews, extradition cases in Canada typically take 1 or maybe 2 days. But in Hassan's case, it had went on for a long time. We were able to bring experts to challenge the handwriting. Usually in extradition, all the requesting state have to supply is a summary of the evidence certifying that it is available and would justify prosecution in the requesting country. So in Hassan's case, we actually had the handwriting reports that we were able to challenge. So it went on for some time, and we were able to call expert evidence. This is probably one reason. The other is the reliance on secret and sourced intelligence. There is reliance on secret intelligence in security certificates, but in extradition cases, I believe this is probably the first case in which the allegations were based on unsourced intelligence of unknown sources and unknown circumstances. But maybe Gary could add why Hassan's case have taken so much attention.
Okay, Gary, what do you think? That why it's received such a high level of public attention in Canada? Those who are immersed in this case, is it getting a lot of press coverage across Canada?
It's getting a fair amount, yes.
Yeah,
especially the Ottawa Citizen has been very good about reporting the Hassan case, and its articles, Chris Cobb in particular, his articles have been distributed across Canada, and so every newspaper syndicates the articles about Hassan. So a lot of people know about the Hassan Diab case. And Rania's right. It's basically, this is a challenge to the underlying evidence of the record of the case. The record of the case is just simply suspicion, and and allegations. Allegations that prosecutors say they can support in court. And we have only the prosecutor's word for it. That's the way the Extradition Act is written, and that's presumptively reliable. Yeah. What has happened here is there's been an attempt to show that the record of the case is not reliable, and they succeeded. Let's face it. Two of the handwriting experts who based their analysis on the wrong handwriting in the first place were removed, and the third one inserted on short notice, 21 days training, as has been mentioned. And this is the pivotal evidence, supposedly, and it's a second kick at the can, and there could be a third or fourth as far as the Extradition Act is concerned, because it's completely unfair. It's the most unfair statute in Canada, and possibly because other jurisdictions don't have this kind of procedure in quite this way. It's probably the least fair act on earth, and that's
I wanted to contextualize this case a little bit, and maybe just throw out the idea why that has received such high level of public attention. That first of all, Hassan is an Arab, Hassan is a Muslim, and in France this is a terrorism case. And in the political context in which we live, would that not have an impact on the level of coverage that is being it's getting, or what do you think?
Yes, of course. I mean, the consequences are huge when you consider that there was an allegation of 4 deaths and of people injured. We're talking about a case that's 40 years old. We're talking about press coverage that ultimately does generate complexity. But the underlying principles are challenged right to the very roots. The underlying principles of extradition are now being challenged not for the first time, but in the most protracted way by Mr. Bain. And he's a bulldog. Basically, he has defended Mr. Diab right to the bitter end, and will continue to do so, I'm sure. This is one of the reasons why there's so much attention given to this particular case. Okay. There are other cases that you can think of, I suppose. Some of the I'm just trying to think something that's come close. You come back to the death sentence cases, the Charles Ng case, which went on for 2 years, and the Behrens case, which went on for many, many years. But basically, nothing has been quite as distilled as this one, and it's mostly because post-Behrens and because there was hope, that was expressed in the Ferris case, hope for people who are being extradited, but Canada's justice system would at last mean something. The judges would have the moral fortitude and the courage to stand up, and the courage of their convictions to stand up and stand for justice, instead of simply following along in the path of precedent.
Okay, we're going to go on to the second question we have from our viewers. It's for you, actually, Gary. So you're on the hot seat now. Can the Justice Minister stop Hassan's extradition, and on what grounds?
Yes, the Minister of Justice can stop the extradition of Hassan Diab, and basically it could be on a number of grounds, including the notion that he isn't going to get a fair trial, and the notion that they've fiddled around with the evidence. If the first 2 handwriting experts relying on the wrong individual as a precedent, as a standard for determining the handwriting that was on the hotel receipt or hotel bill, whatever it was, if they came to the conclusion that handwriting was parallel to Hassan Diab's, then how can the third handwriting expert come forward at the 11th hour and say, I am here to save the day, and basically determined that this new sample is in fact somehow related to Hassan Diab on the basis of 5 words. I mean, it's just absolutely absurd that we would be sending somebody back to face such horror. And even if you look at France's system as being completely just, it's still a horror because he's going to be years in prison before he gets justice, before he gets a trial. So it makes give your head a shake. Now, the Minister of Justice reverse all of this? Yes, because it's a political decision ultimately. And the Minister of Justice is ultimately the person who determines whether or not a person is going to be sent back. He does so with all the political baggage that entails. Because it's a political decision, he's going to be susceptible to a certain extent to the expression of the conscience of Canadians. We come back to that again and again, because that is the final determiner. And if we have a letter writing campaign and a petition and so on, which says Canadians are completely disgusted by the extradition process, the extradition law, and the fact that judges don't have power, and the fact that the Minister of Justice is a big daddy in this whole operation, and this shouldn't go forward, and that Hassan Diab should be allowed to continue in Canada and get his job back and so on. Well, all of that is something that the minister has the power to do.
Okay. We're going to go on to the third question. That's good. This question's for you, Matthew. What conditions should Canada place on extradition in order to better protect Canadians, in your opinion?
Well, I think that's really a question for Dr. Botting. But
they put your name on it, but we can both discuss it. Yeah.
But I definitely think that you should not lose the rights that accrue to you with Canadian citizenship or refugee status or permanent residence in this country when another country seeks you. You should have the same criminal law standards that would be applied if you were charged with a crime here in Canada.
Okay. Okay, I'm going to go back to you.
But I'm actually wondering if Dr. Botting, if you could actually comment on that, because I think as this case goes up, the Supreme Court might ask that same question. Well, what would make this a fair process?
Well, obviously we can't quite go back to the entire criminal value system where there's, okay, we have the presumption of innocence. There's no question about that because no trial is being conducted. But the point of abandoning your rights once you leave the country is a good one. And again, the Supreme Court of Canada said this in the Ferris case. Madam Justice McLaughlin said that basically judges have to be very circumspect about extradition cases because the individual is losing his rights. As soon as he steps out of Canada and is back in France, for example, there are no more protections. His rights are gone as far as Canada is concerned. His charter rights have disappeared. What has happened, ironically, is that we've built up the rights, and the charter rights have been evolving for centuries and were distilled in the Charter of Rights. There are still many other rights besides the Charter of Rights. For example, the right against abusive process, which is covered under the Charter, but is also covered by common law. These rights, though, are denied the individual once he is removed from the country. And even though this is mentioned in Ferris and emphasized in Ferris, the Ontario Court of Appeal seemed to give that almost no consideration.
Okay, we're almost out of time, and I would just like to direct the last question to Rania. The federal justice minister, Nicholson, seems to have the final say on transferring your husband to France. So ultimately, this is a political decision, and what efforts have been made to lobby the justice minister, and what are you calling on your supporters to do?
Okay. The law allows us to make submissions to the justice minister asking him not to surrender Hassan and to give reasons, and we plan to do that because France relies on secret unsourced intelligence that cannot be tested. The handwriting analysis, which is key to this case, will not be challenged. We will also be submitting a Human Rights Watch as well as handwriting reports that we code in this case, and additional handwriting reports from France that testify that this handwriting evidence against Hassan is worthless. We are asking people to write to the Justice Minister in order to ask him to stop Hassan's extradition. So this will be the first process. Then we are going to appeal Justice Moranger's decision to the Ontario Court of Appeal. We will also be appealing any potential surrender decision by Minister Nicholson. And eventually, if we lose, we will take it to the Supreme Court. So we are calling for people to write to the Justice Minister, to write to organizations, to ask them to get involved in this case, to contribute to Hassan's legal fund, especially that he has to pay $2,000 each month, and he's not working, and he was fired from his job. So this is what we have in mind.
And also we are starting a pledge fund in which we are seeking 100 individuals across this country, and there's plenty more who contribute, to contribute at least $20 a month. It's not a lot. It's a couple coffees or a couple of beers to this fund, so that the cost of Hassan's very limited liberty is not borne any longer by Rania and Hassan. It's ridiculous that to get out of jail, you now have to pay the government $2,000 for your surveillance costs. So we're hoping that people will get in touch with us at the Justice for Hassan Diab Committee, or they can email task, T-A-S-C, at web.ca for more details on how they can be a monthly pledge individual to help out, because this has been a huge burden that has been borne by Hassan and Rania.
I wanted to remind the viewers that the Hassan Support Committee has a website. It's Justice for Hassan Diab, that's HASSANDIAB.org. Justiceforhassandiab.org, and all of this information, including all the media reports and everything to do with the case, is on there if you want to get in touch and support. So you know, this case, and you're correct, it's going to cost, you know, a lot of money, and they need your support, both financially and your moral support. So I want to thank everybody. That's all the time we have for now, and I want to thank our guests, Rania and Matthew and Gary Botting from Vancouver for your contributions, and I want to thank the listeners for joining us, and we hope that you'll join us again for another edition of Prism TV Rights and Security. Have a good day.